All right, we are live on Facebook. Hello, everyone. Good afternoon. My name is Maria Hall. I'm a lawyer and I'm here with two other lawyers today, and we're going to be doing a Know Your Rights class on California's lemon laws, which are consumer laws, consumer protection laws to protect you when you try to buy a car that doesn't work properly. So today the presentation is going to be led by Yeva Haroutunian and for the English portion, and then the Spanish is going to be translated by Roberta Ponce. So I will go ahead and let you two again. Oh yeah, and of course our gracious host SBCC is amazing. So I'll go ahead and turn it over to Yeva to start your PowerPoint.
Thank you, Maria, and thank you, Roberta, for translating.
Oh yeah, and
Roberta, thank you, Yeva.
And Roberta, you may want to translate what I just said too.
Okay.
Entonces,
lo que María acaba de decir, buenas tardes, yo me llamo Roberta Ponce. María es una licenciada y nosotras, Yeva y yo, también somos licenciadas. Y ahora el tópico va a ser leyes de limón sobre cuando uno compra un carro que no funciona bien. Entonces ahora vamos a hacer todo lo posible para darles la información que tal vez les ayude cuando estén comprando un carro.
Gracias. Okay, so we'll turn it over to Yeva with these slides.
Are you able to see that?
Yes.
Okay. So my name is Yeva Haroutunian. I'm an attorney, and I've been working at a lemon law firm for about 4 years. 4 years as a law clerk while I was in law school, and now as an attorney. So today we are going to discuss the Song-Beverly Consumer Warranty Act, which is also known as the California Lemon Law.
Entonces, lo que acaba de decir Yeva es que ella es una licenciada, se llama Yeva Haroutunian, y tiene 4 años de experiencia trabajando en un taller de licenciados donde se dedican a las leyes de limón sobre diferentes productos, y ahora va a discutir el Song-Beverly Consumer Warranty Act.
Okay, just as a disclaimer, the following information is not considered legal advice. We're not giving legal advice to anyone specifically, but this is solely informational. If you do have any issues, legal issues, please contact an attorney and consult with your attorney. So we'll be discussing California state law, and these laws are subject to change without notice.
Lo siguiente es solo informativo, es información y no sustituye el asesoramiento legal. Si tienen problemas legales, por favor, consulten con un abogado. Analizaremos ahora las leyes bajo el punto de vista de California, de las leyes de California. Las leyes están sujetas a cambios sin previo aviso, entonces siempre busquen la información.
Okay, so first we're going to quickly discuss what is the California Lemon Law exactly. And its main purpose is consumer protection. So it is designed to protect the rights of consumers. And consumers are just those who purchase products or even lease products, as we will discuss. So the Lemon Law, or Song-Beverly Consumer Warranty Act, is California Civil Code Section 1790 to 1795.8. If anybody wants to look into that, that's the reference. And this is a remedy for consumers, buyers of retail products or consumer goods that have repetitive defects that are under warranty. So you have a defect with a product, or in this case, in this PowerPoint, I'm mainly going to discuss cars. If you do have a defect with a car and you keep taking it in for repair, but it doesn't get repaired and you keep having this problem, you shouldn't have to keep that car or have to deal with that problem. So this law is designed to help anybody in that situation.
You probably have a Spanish slide.
Okay, then I'll just finish this slide and get to that slide.
Okay.
So specifically consumer goods means any new product that is bought or leased for use that is primarily personal, family, or household purposes. This doesn't include clothing or consumables, and it includes new and used assistive devices. That's supposed to be assistive devices. So we'll go in order. We mainly deal with new products, but we do deal with some used products depending on the case. And it could be either purchased or leased. And when it says use primarily for personal, family, or household purposes, this mainly means that anything you use for yourself, for your family, it covers a broad range of products. And it also covers products that are used for business purposes, but it depends on the size of the business. So specifically when it comes to cars, it's usually, you usually have to have 5 cars or less, and the cars can't be too heavy because then it becomes more commercial. So the criteria is 5 or less cars and less than 10,000 pounds. So the lemon law applies to cars and other vehicles like boats, RVs, trailers, motorcycles. And it could also apply to other appliances like refrigerators, dishwashers. It could even apply to phones and computers. And assistive devices are like wheelchairs or canes or hearing aids, those sort of products. And specifically in regard to vehicles, this is the California lemon law, so the cars need to be registered in California.
Vamos a discutir qué es la ley del limón de California. Pues se dedica a la protección al consumidor. Entonces, hay un código civil de California que el número numérico es 1795.8 y como les hemos dicho en otras charlas, pueden ir a la biblioteca de leyes en downtown Los Ángeles, en el centro de Los Ángeles, y pueden buscar estos códigos. Están en inglés y en español y les pueden asistir con esa información. Se dedica al remedio para los consumidores de productos al por menor con defectos repetitivos que se encuentran en garantía. So, tiene que haber una garantía y los productos generalmente tienen que ser nuevos. Cualquier producto nuevo comprado o arrendado para uso principalmente personal, familiar o doméstico, excepto ropa o consumibles, incluye dispositivos asertivos nuevos y usados. Se aplica generalmente a automóviles y otros vehículos como barcos y vehículos recreativos. También se aplica a electrodomésticos como refrigeradores, lavadoras, teléfonos, computadoras, sillas de ruedas, las sillas de ruedas electrónicas y el producto tiene que ser registrado en California para ser efectivo la ley, para que se aplique.
Okay, why this is important. A lot of people don't know about this law, and as a result, they don't know that this law applies to them. So when they do deal with these issues, they don't know what to do, and they oftentimes just think that they have to deal with this problem. Because what happens is people experience these issues and they just keep taking their cars to the dealership, and the dealership doesn't really help them or doesn't fix their problem, and they just feel stuck and that they don't have anything else to do. So there is a solution, and we are going to discuss that in detail. So another reason is buying or leasing a car is a really big investment. It costs a lot of money, and it's usually the second most expensive purchase people make other than buying a house. Additionally, we want to drive cars that are safe and free of defects because our safety is depends on how the car runs. We have expectations that the car will work properly, and when those expectations are not met, we get worried and sometimes get scared of driving and have to deal with this burdensome process of constantly taking our car into the dealership. So some people also we've had clients that are constantly worrying about when the defect's going to happen again, whether they can drive their car. You have your kids in the car, you have your spouse in the car. There was a client who was worried that his pregnant wife has to drive the car and has to deal with these issues. Some people can't even drive their car because it's to a point where you don't know when the defect's going to come up, and people are driving the freeway. It might happen in the freeway. So they just keep it parked and they have to pay for something that they can't even drive. All right, next slide.
¿Qué es la ley del limón de California? ¿Por qué es importante? El compro de carro, aparte del compro de una casa, es uno de los más grandes inversiones de dinero que uno hace. Entonces, por eso mucho de la ley se enfoca en el compro de carro. Comprar o arrendar un automóvil es una gran inversión. Segunda compra más cara después del compro de una casa. Queremos conducir autos seguros que estén libres de defectos. Tenemos expectativas de que el coche funciona correctamente. Entonces uno se mete en su carro y espera que va a conducir bien y que no va a haber problemas, que las llantas no van a explotar, que el motor va a seguir funcionando. Uno se preocupa cuando el defecto sigue ocurriendo, no se siente seguro, entonces emocionalmente nos afecta. Lleve el automóvil a concesionario para que lo reparen, y lo que pasa es que el problema sigue y uno se siente menos y menos seguro. No poder conducir su automóvil es un problema porque luego uno lo tiene estacionado y a veces quizás pague por un Uber o un Lyft o rentar otro carro, y es otra inversión de dinero. Y uno se pregunta, ¿por qué estoy pagando por esto?
Okay, so in order to understand how the lemon law works, we need to cover the fundamental aspect of the law, which is that the warranties. So there are three types of warranties. The first is the express warranty, which is an actual physical booklet. It's the warranty booklet that comes with the car when you purchase or lease a car. So specifically, according to the Civil Code section, an express warranty is a written statement arising out of a sale to the consumer of a consumer good, where the manufacturer undertakes to preserve or maintain the utility of performance of the consumer good, or to provide compensation if there is a failure in utility of performance. So that basically means that the manufacturer in a written statement is promising to preserve or maintain the car, the use of the car. So they're warranting that you're going to have a good car and that they're going to make sure that, like, repair it basically. And it's not necessary to use formal words such as warrant or guarantee. But if they are used, then you know that it is a warranty. So when you see the warranty booklet, you know that you're dealing with an express warranty. Also, when you're dealing with a dealership representative, any opinion that they give or affirmation, that's not considered to be an express warranty because it's mainly their opinion. So what we're looking at is what information is included in the physical express warranty, which is the warranty booklet.
Entonces, hay diferentes tipos de garantías. Hay una garantía expresa, que es otra vez el Código Civil 1791.2. Y esa garantía es expresa. Quiere decir que no hay campo para interpretación, es expresa, dice, garantizamos esto. Es una declaración escrita que surge de una venta al consumidor de un bien de consumo, donde el fabricante, distribuidor o minorista se compromete a preservar o mantener la utilidad o desempeño del bien de consumo o proporcionar compensación si hay una falta en la utilidad de desempeño. En ese caso de cualquier muestra o modelo que la totalidad de la mercancía se ajuste al muestra o modelo. No es necesario para la creación de una garantía expresa que se utilicen palabras formales como garantía o garantía expreso, pero si se utilizan tales palabras, se crea una garantía expresa, una mera afirmación de valor de los bienes o una declaración que pretenda ser simplemente una opinión o un elogio de los bienes, no crea una garantía expresa.
So we discussed express warranty. There are also implied warranties. There are two implied warranties. The first is the implied warranty of merchantability. This is not in a physical form like the express warranty is. This is just present when there is a sale of a good, a sale of a vehicle. So the implied warranty of merchantability basically means that the manufacturer is guaranteeing that the product is merchantable, which means that it is good for purchase. That is the implied warranty of merchantability, that that the car is going to run the way it should run or the way it ought to run. So specifically, you can refer to California Civil Code section 1791.1. It states that the consumer good meets each of the following. So there is a pretty strict standard. It must pass without objection in the trade under the contract description. So when you buy a car, you get a purchase contract or a lease agreement. It's usually that long yellow or white paper. It's really, you could tell which one it is. It's the really long one. So in your vehicle needs to pass the contract description without objection. It needs to be fit for the ordinary purposes for which such goods are used. So when it comes to vehicle, this is transportation, safe transportation. You want to be able to properly get from point A to point B without any issues. The vehicle needs to be adequately contained, packaged, or labeled. This doesn't really have to do with cars except for probably the labeling, which we will discuss in a later slide. And it must conform to the promises or affirmations of fact made on the container or label. So we will also discuss this in a later slide, specifically when you see a car that's labeled as is or lemon law buyback. So we'll go over that so you guys could be aware of what to expect. And the second type of implied warranty is the implied warranty of fitness for a particular purpose, which basically means that when a retailer or manufacturer, so basically when the car manufacturer or dealership, when they have reason to know of any particular purpose for which the consumer goods are required, and when the buyer is relying on the skill and judgment of the seller to select and furnish a suitable good, then there is an implied warranty that the goods shall be fit for such purpose. So obviously when you go to a car dealership, they already know the particular purpose for which you are going there. You want to buy a car or lease a car that runs well. And also, as the buyer, in a way, you are relying on their skill and judgment since they deal with cars, they work on the cars, they inspect the vehicles, that they will be able to sell or lease you a properly working vehicle. So that is the implied warranty of fitness for a particular purpose.
Entonces, otro tipo de garantía es una garantía implícita y se puede encontrar en el Código Civil, sección 1791.1. Garantía implícita de comerciabilidad dice que los bienes de consumo cumplen con cada uno de los siguientes. Pasar sin objeción en el comercio bajo de la descripción del contrato. Son aptos para los fines ordinarios para los que se utilizan dichos bienes. Están adecuadamente contenidos, empacados y etiquetados. Cumplir con las promesas o afirmaciones de hecho hechas en el envase o etiqueta. Garantía implícita de idoneidad es otro tipo de garantía y esta garantía dice que cuando el minorista, distribuidor o fabricante tiene motivos para conocer algún propósito particular para que el cual se requieren los bienes de consumo y además que el comprador confía en la habilidad y el juicio del vendedor para seleccionar y proporcionar bienes adecuados. Entonces, hay una garantía implícita de que los bienes serán aptos para tal fin. So, por ejemplo, tú quieres ir a comprar clubs de golf. Entonces, hablas con el representante de la tienda, él te da su opinión basada en el juicio que tiene como vendedor, como representante del vendedor. Y tú, como no sabes nada, estás completamente en las manos del juicio del vendedor. Y esa es una garantía implícita al propósito particular.
So, so far we've gone over the types of warranties. There are 3 of them: an express warranty, 2 implied warranties. So now we're going to discuss disclaimers. So unless disclaimed, the manufacturers and retail sellers, the dealerships, implied warranty of merchantability is included in the purchase. So that basically means that they can disclaim this warranty. They can do this by labeling the vehicle as is or with all faults. And there are requirements that they have to follow in order to properly disclaim a warranty. One of those is that the disclaimer needs to be in writing and it needs to specifically state as is or with all faults. This is so that they don't do anything that's vague or ambiguous that later hurts you and results in a misleading statement. So when a consumer does purchase a vehicle that is as is or with all faults, this constitutes a waiver by the buyer of the implied warranty. And the disclaimers does not apply to express warranty. So the manufacturer and dealer, they can't disclaim an express warranty. There has to be an express warranty. And they also cannot limit implied warranties within the express warranty.
Entonces, en discutir los tipos de garantía, también hay descargos de responsabilidad que son un poco diferentes. A menos que se rechace la garantía implícita de comerciabilidad del fabricante y del vendedor minorista, se incluye en la compra. ¿Cómo es o con todas las fallas? Quiere decir que pues es una adversión al comprador, ¿verdad? Ese escrito constituye una renuncia por parte del comprador a las garantías implícitas. No aplica para garantías expresas. No se pueden limitar las garantías implícitas dentro de la garantía expresa.
So we have our warranties now. We are going to discuss the statute of limitations and the warranty period. So these are important time periods that as a consumer, you should know about so that you know during what period of time you could bring a lawsuit or even how long your warranty period is. So the statute of limitations is a term that means the time period during which you can file a lawsuit. So you don't have many years to file a lawsuit. If you do have a lemon, you have to do it within the statute of limitations. And that is 4 years from the time the buyer discovered the defect or should have known about the defect. So you only have up to 4 years. Let's say you discovered the defect 3 years ago when your car had engine issues at 12,000 miles. You only have a year left to file a lawsuit. And so you have to be aware of this so that when an issue does arise, you know how fast you need to move. It also takes time for these issues to repeat themselves if God forbid they do repeat. So as soon as you have an issue that happens once or twice, you should start considering that you might have a lemon and that you might need to consult with an attorney about what your next step should be. The second important time period is the warranty period. This is important because lemon law covers defective parts that are under warranty and that arose during the warranty period. So lemon law doesn't cover every issue. It covers material and substantial defects like engine problems, airbags, transmission. It doesn't cover, as you'll see in the following slide, wear and tear or let's say aftermarket parts. It's pretty specific and you can see what parts are covered by taking a look at your warranty booklet. The warranty period is included in the warranty booklet as well as what parts are covered. So usually what you'll see as a warranty period is usually 3 years, 36,000 miles. It could be 5 years, 60,000 miles. It varies. So you should have a look at that to see how long your warranty lasts. And this is the general warranty, which covers a broad range of parts. And it's 3 years, 36,000 miles, whichever comes first. So let's say you only had your car for 2 years, but you're already at 40,000 miles, your warranty ended at 36,000 miles. Some people also have a separate powertrain warranty that comes after the general warranty. So usually what we see is people have a 3-year, 36,000 mile general warranty. And then after that ends, the buyer has up to 5 years, 60,000 miles on powertrain warranty. And the powertrain basically covers the engine and the drivetrain, which is what moves your car forward. So you have, after your 3-year warranty ends, you have an additional 2-year and almost like less than 30,000 mile additional warranty that covers specifically the powertrain.
Hay periodos de tiempo que son muy importantes cuando uno hace una compra así de carro, de casa, que son importantes regulaciones. Se llaman estatuto de limitaciones y periodo de garantía. Entonces, estatuto de limitaciones quiere decir el periodo de tiempo durante el cual puede uno presentar una demanda. 4 años desde el tiempo que el comprador descubre el defecto o debería de haber descubierto el defecto, porque a veces el defecto no es aparente inmediatamente o quizás lleva, por ejemplo, el carro que se componga y por un tiempo está bien, pero luego el problema sigue ocurriendo. Hay un periodo de garantía que es diferente del periodo de estatuto de limitaciones. La ley de limón cubre las piezas defectuosas que están bajo garantía y que surgieren durante el periodo de garantía. Warranty period incluido en un libro, en un folleto. Garantía general de 3 años o 36,000 millas. Garantía general es de 5 años o 60,000 millas, 60,000 millas. También podrá atender una garantía separada del tren motriz que viene después de la garantía general. Ejemplo, el comprador tiene una garantía general de 3 años, 36 millones de millas. Después de que termine, el comprador tiene una garantía del tren motriz de hasta 5 años o 760,000 millas que cubre las reparaciones de garantía del motor del tren motriz.
Specifically, when it comes to the types of defects consumers experience, the defects have to be repetitive and substantial, meaning that they have to occur more than once and they have to be material defects. So as a consumer, you must give the dealership a reasonable number of attempts and a reasonable amount of time to repair the defect you're experiencing. A reasonable amount of time is considered within 30 days, so up to 30 days. You shouldn't have to have your car in the dealership for more than 30 days. That's already a long time. A reasonable number of attempts is at least 2 repair attempts. It could be more. So depending on the case, 2 might not be enough. So this reasonableness depends on every case. Substantial defects include those covered in the express warranty. So if you could always take a look at your warranty booklet to see what parts are covered. So when you do have an issue, you just open up the warranty booklet and find out whether that issue is covered or not. These defects do not include normal wear and tear. That is not something the lemon law covers, and it doesn't really include noises. But if you do hear a noise, it could be an underlying issue, which could be a material defect. So make sure to, whatever happens to your car, whatever noises you hear, take it into the dealership and then possibly have an attorney evaluate your paperwork to see what the issue is. It does not include defects as a result of unauthorized or unreasonable use. So as a consumer, you do have a responsibility to take care of your car. So if you're not changing the oil on time and then you later have engine issues, that's not going to help your case. And that might even cause the engine issues. That's not something lemon law will cover. And if you do happen to get in an accident and then you start to get issues relating to what was damaged, that is also something that will be covered. As I mentioned before, this does not include aftermarket parts. So any accessories that you add to the car, that is not included if it does get damaged. And you need to have allowed the dealership to attempt to repair the vehicle. Sometimes when you do take your car into the dealership and they inspect your vehicle, they might write no problem found, or in short, NPF. This might not really mean that there's not a problem found. So don't think that you don't have a problem. So oftentimes we see that the dealership will include all this other information about what they did during the inspection. So they'll actually work on the car and they will find an issue and repair that issue or work on repairing that issue, but they still will write no problem found. So you need to be aware of what they're writing and actually see what is in the body of your repair order.
Disculpe que en la discusión previa me confundí un poco con los números y nomás quería aclarar que 60,000 quiere decir 60,000 y que 70,000 quiere decir 70,000. So, por favor, disculpen mi error. Me confundí con los números. Ahora vamos a discutir defectos del producto. Repetitiva y sustancial. Debe dar un número razonable de intentos y tiempo para reparar el defecto. So, uno cuando lleva su carro no puede decir, pueden, por ejemplo, trabajar en el carro por 6 meses o 9 meses. Tiene que ser un tiempo razonable que van a hacer la reparación. Y tiempo razonable se considera dentro de como 30 días. Los defectos sustanciales incluyen los cubiertos por la garantía expresa. No incluye un desgasto normal, ruidos, neumáticos, algo así que pues se descarga con el uso diario. No incluye eso. No incluye defectos como resultado de un uso de sin ser autorizado o que es irrazonable. Entonces quiere decir como una secadora de pelo, ¿verdad? La máquina, uno no puede decir, lo voy a meter en el agua para calentar el agua de mi tina de baño. Ese es un uso irrazonable. No incluye piezas del mercado de accesorios. Necesidad de haber intentado reparar el vehículo. Entonces uno tiene que enseñar que sí trató de hacer la reparación razonable. A veces no hay ningún problema encontrado y eso es lo que escribe, por ejemplo, el mecánico. Entonces uno tiene que poner cuidado en la disposición que especialmente mecánicos hagan, especialmente mecánicos que trabajan por los dealerships como Ford, Hyundai, los diferentes fabricantes y vendedores de carros, porque quizás a veces pongan ningún problema encontrado, pero el problema sí continúa.
Another way it might be considered that your car has had a reasonable number of attempts at repair is under the Tanner Consumer Protection Act, which is what we call a presumption. It basically is presumed that when a reasonable number of attempts have been made to conform your car to its express warranty, if either within 18 months from the date that you purchased or leased your car, or the first 18,000 miles, whichever comes first, the following three things, one of the following three things happens. So basically, if within the first 18 months or 18,000 miles, any of these happens, it could be considered a reasonable number of attempts to repair your car. So the first thing we have is that the defect results in a condition likely to cause death or serious bodily injury. This is considered a reasonable number of attempts, and you have to at least once directly notify the manufacturer of the need for repair of the defect. The second way is when the defect has been under repair 4 or more times, and you have to also at least once directly notify the manufacturer. And the third way is that the vehicle has been in service or under repair for 30 days or more. You need to, in order to find out if in this case you need to at least to notify the manufacturer at least once, is you have to check your warranty or owner's manual to see if there is such a requirement that the buyer needs to notify the manufacturer about the need for repair of the defect. So what we see most of the time is numbers 2 and 3. Is that within the first 18 months or 18,000 miles, the car has been in for repair either 4 or more times or for 30 or more days. There is an exception. So if there is a qualified third-party dispute resolution process, which manufacturers tend to have, and the buyer is timely notified of this resolution process, the presumption is put on hold until the buyer has resorted to this process. But if the buyer is dissatisfied with the third-party decision, the buyer may assert the presumption. So a qualified third-party resolution, dispute resolution is what we see mostly as arbitration or a mediation. And these two processes are an out-of-court method, and both parties are, or all the parties are included. And there's either an arbitrator if it is an arbitration, or a mediator if it is a mediation. And the purpose of these processes is to resolve the dispute out of court. The difference between these two is that an arbitration is binding while a mediation is not. So an arbitration is more, the decision is a final decision. And in mediation, the mediator is basically there to facilitate discussion and try to get to a resolution.
Entonces, acerca de defectos del producto, hay un acto que se llama el Tanner Consumer Protection Act, que protege consumidores. Se presume que se ha realizado un número razonable de intentos para ajustar un vehículo motorizado nuevo a las garantías expresas aplicables si dentro de 18 meses desde la entrega al comprador o 18,000 millas. Lo que ocurre primero ocurre uno o más de los siguientes. El defecto de como resultado una condición que probablemente cause la muerte o lesiones corporales graves 2 o más reparaciones y el consumidor ha notificado directamente el fabricante al menos una vez sobre la necesidad de reparar el defecto. So, uno de comprador tiene que tratar directamente con el fabricante unas 2 o 3 veces para enseñar, mostrar que sí ha tratado de resolver el problema razonablemente. El defecto tiene que haber estado en reparación 4 o más veces, al menos una vez notificado directamente al fabricante. Entonces, si uno lleva su carro la primera vez, quizás el defecto es cubierto por este acto, pero tiene que llevar su carro varias veces a que se componga y no nomás inicialmente a la primera vez. El vehículo está fuera de servicio en reparación por más de 30 días. Eso se considerará un problema que está cubierto sobre este acto. Verifique la garantía o el manual del propietario para conocer los requisitos de que el comprador debe notificar al fabricante directamente sobre la necesidad de reparar el defecto. Si existe un proceso de resolución de disputas de terceros calificados y se notifica al comprador oportunamente, la presunción se suspende hasta que el comprador haya recurrido el proceso de resolución de disputas de terceros calificados. Si es si es el comprador no está satisfecho con la decisión del tercer calificado, el comprador puede hacer valer la presunción. Arbitraje o mediación, métodos extrajudiciales que con ambas partes y un árbitro o mediador designado para resolver la disputa. El arbitraje es vinculante y la mediación no es.
The remedy that lemon law provides is found in California Civil Code section 1793.2, subsection D, subparagraph 1. And it basically states that if the manufacturer or its representative in this state, which is a dealership, does not service the goods to conform to the applicable express warranties after a reasonable number of attempts, the manufacturer shall either replace the goods or reimburse the buyer in an amount equal to the purchase price paid by the buyer, less the amount directly attributable to use by the buyer prior to the discovery of the nonconformity. So this basically states that when a consumer does deal with all these issues and does have repetitive defects, when you have taken your car in multiple times to get serviced or repaired and the dealership just hasn't been able to fix your problem to repair this issue, then you do have a remedy, which is that the manufacturer can either replace your car or reimburse you for the money you put into your car. And so you get this certain amount, but the amount is subtracted by the amount that you didn't have any issues with the car. So we'll go over an example in the next slide. But you basically get reimbursed for the amount you put in your car after the defect arose. And the manufacturer, you get to choose. So the manufacturer can either replace your car with a new vehicle that is substantially identical to the defective car that you had, or it could make restitution in an amount equal to the actual price paid or payable by the buyer.
Según el Código Civil, sección 1793.2 D1, si el fabricante o su representante, como por ejemplo en un taller de carros donde se venden carros, pues es el fabricante y luego el representante es el que les vende el carro. En este estado no repara o repara los productos para cumplir con las garantías expresas aplicables después de un número razonable de intentos, o fabricante reemplazará los productos o reembolsará al comprador una cantidad igual al precio de compra pagado por el comprador, menos la cantidad directamente atribuible al uso por parte del comprador antes de descubrimiento de la no conformidad. Reemplazar el vehículo con un nuevo vehículo motorizado que sea sustancialmente idéntico, o hacer restitución en una cantidad igual al precio real pagado o por pagar por el comprador.
Now we will discuss how we calculate the damages. And damages are basically it begins from the mileage the vehicle was first presented to the dealership for repair. So it is very important that when you do see that your car is having a problem or an issue, that you take it to the dealership as soon as you can. You want to do this for your own safety, and you also want to do this so that you could record it and have it in writing that you had this issue at this mileage, and this is what the dealership found and worked on for this issue. An example we have is that, let's say your car begins to have engine problems at around 12,000 miles, and you take it into the dealership for repair. Your damages begin from 12,000 miles. Anything before 12,000 miles is considered what we call good miles, because your car was operating properly. So you didn't have an issue before 12,000 miles. You're basically going to get reimbursed for 12,000 miles and on. This, unfortunately, it doesn't count if you have engine problems beginning at 8,000 miles and you don't take your car in for repair, because then we don't have any record of you having an issue with your vehicle from 8,000 miles. That's why it's important to take in your car as soon as possible and to get the written repair order from the dealership, which is basically a summary of the issue that you had and whatever they worked on in your car. So it counts from the mileage that you take your car into dealership for a repair or of the defect. There is a formula to calculate the worth of the good miles, which is subtracted from the total net recovery. As you saw on the last slide, you get reimbursed for the amount that comes after, in this case, 12,000 miles. And from that total amount that you do get reimbursed, we subtract the good miles. In this case, the issue began at 12,000 miles. We don't count it from before 12,000, we count it from after. And the formula is the actual price of the car times the mileage at the first repair divided by 120,000 miles. The 120,000 miles is what we consider the life of the car. So, I mean, you could obviously have your car after 120,000 miles, but for the purposes of this statute, we consider the life of the car until 120,000 miles. And in this example, let's just say that your car is worth $30,000 and that you did take in your car to a dealership at 12,000 miles as the first repair. So we multiply 30,000 miles to 12,000 divided by 120,000 miles, and we get a total of $3,000 in good miles. So you're not going to get reimbursed for this. You're not going to get reimbursed this $3,000 because it is considered the worth of the good miles that your car had. So this is the amount that is subtracted from the total amount, and but you do get reimbursed for after this 3,000 miles, you do get reimbursed for what you had to suffer having a defective vehicle.
Entonces, vamos a discutir los daños y perjuicios. El cálculo de daños. Los daños comienzan desde el millaje en que el vehículo se presentó por primera vez al concesionario para su reparación. Entonces, no empieza cuando tú te das cuenta, pero cuando representas el daño al concesionario. Ejemplo, los problemas del motor comenzaron a las 2,000 millas, 12,000, disculpe, 12,000 millas y 12,000 millas y el comprador lleva el auto al concesionario para que lo reparen. Los daños comienzan a acumularse a partir de los 12,000 millas. Cualquier cosa antes de los 12,000 millas se considera buenas millas porque el automóvil funcionaba correctamente. No empiezan los defectos hasta que uno presenta el carro al concesionario. En este ejemplo fue a los 12,000 millas. No cuenta si los problemas del motor comenzaron a 8,000 millas y no llevó el automóvil a repararse. Si usted se dio cuenta a los 8,000 millas, pero no llevó el carro al concesionario, entonces esas millas no cuentan hasta que lleve uno a reparar su carro. Formular para calcular el valor de las millas buenas que se resta de la recuperación total, usan una fórmula, ¿verdad? Precio real del auto más millaje en la primera reparación o 120,000, 30,000 y 12,000 dividido por 120,000, que viene siendo 3,000 millas, $3,000 en buenas millas. Y así usan la fórmula, pero ustedes no se tienen que preocupar mucho por eso hasta cuando lleguen al momento se aplica la fórmula, pero no falten de hacer su demanda, hacer su queja por miedo de la matemática de la fórmula. No hagan eso. Sigan adelante porque tienen derechos por los daños y perjuicios.
Continuing with calculating damages and what you should expect to receive is compensatory damages, which is money awarded to make up for the damages you incurred. And in regard to lemon law, this specifically includes the money you put into your car. This includes the down payment you put in, the registration fees you've been paying, and the loan payments you've been paying on your vehicle. So a lot of people, like, they put in a large down payment. We mostly see like 1,000, 3,000. Some people even put 30,000. They put in a lot of money and you want that money back because you're dealing with a defective vehicle. So this is just some of the things we consider when calculating damages. Obviously, it varies case by case because everybody deals with a different situation and different damages. And your damages also includes incidental damages, which is costs you've incurred to prevent further loss. So any rental costs, repair costs, towing costs, and storage costs you've had to pay out of pocket to deal with this defective vehicle, we're gonna try we're gonna try to get that back to you. So basically, you shouldn't have to put money into something that is not up to the warranty, is not up to standard. So you do deserve to get that money back. And this is just a brief list of what you should expect to get back.
El cálculo de daños es algo que vamos a discutir. Los daños, hay daños compensatorios, que es dinero otorgado para compensar los daños sufridos, los daños reales que uno sufrió. Incluye el dinero que pones en tu coche, como el pago inicial, cuotas de registro, pagos de préstamos. También incluye daños incidentales incurridos para evitar pérdidas adicionales. Por ejemplo, tú tratas de componer algo que está mal en el carro y haces un arreglo y otro arreglo. Esos son daños incidentales. Costos de alquiler, reparación, remolque y almacenamiento.
Another aspect to consider when it comes to lemon law is the civil penalty. So not all cases qualify for a civil penalty, but a civil penalty, you could get a civil penalty of up to 2 times your damages if one of the following happens. So if the buyer can establish that the manufacturer's failure to comply was willful, or if there's a violation of Civil Code Section 1793.2. How a buyer usually establishes whether the manufacturer's failure to comply with this whole process was willful is, in one example, if, let's say, the buyer informed the manufacturer in writing about the defects that he or she was experiencing with their vehicle, and they demanded either that the manufacturer either buy back the car or replace the car. If the buyer does this and the manufacturer does nothing and conducts no investigation and doesn't even get back to the buyer about this issue, then that could be considered as willful failure to comply. Another way is if there is a violation of California Civil Code Section 1793.2, which was in this slide, which is the remedy. It basically says that if the buyer has a reasonable number of repairs on their car and the defect still continues, and the manufacturer should either replace the car or reimburse the buyer. And if the manufacturer fails to do this and violates this code section, then that could warrant a civil penalty. So the civil penalty goes up to 2 times. So it could be one time the buyer's damages, or 0.5 or 1.5, anything up to 2 times, but it doesn't exceed 2 times the buyer's damages. And there are exceptions to the civil penalty. So it depends on the facts of the case, and you should definitely consult an attorney regarding your case, and they should be able to inform you on the civil penalty, whether your case qualifies for a civil penalty or could qualify, depending on the specific facts of your case.
Penalidades civiles. Penalidad civil de hasta 2 veces daños del comprador si el comprador establece que el incumplimiento del fabricante fue intencional O ejemplo, por ejemplo, el comprador informó al fabricante por escrito sobre los defectos y exigió la recompra o la sustitución del vehículo. El fabricante entonces no hace nada. Eso va a hacer que las penalidades civiles aumenten. Violación del Código Civil de California, sección 1793.2, explica cómo se calculan y las maneras de que las penalidades civiles se aumentan. Hay excepciones dependiendo de los hechos del caso.
So what happens next? Let's say that you went through this entire process and that the manufacturer has decided to reimburse you. This is the process. So both parties agree on the terms and sign a release, which is a contract that the manufacturer is going to pay this amount and you agree on the terms. The buyer is required to return the vehicle to the dealership, where the dealership inspects the car one more time. And after all these technicalities are dealt with, the manufacturer then sends the check and pays off the remaining loan balance. Attorney's fees apply, but are separate from the client's recovery. And hopefully after all this headache and frustration, we do have a happy client, because in the end, you do deserve to have your money back for having to deal with this. Part of the disclosures that the dealership gives, that the manufacturer gives after a car is a lemon. This doesn't have to do with the specific client's case. This is just to let you know, in case you're going in to look for a vehicle to purchase or lease, you should know about this to help guide you in your purchase or lease. So under the Automotive Consumer Notification Act, which you can find at this code section, when a vehicle is considered a lemon, it needs to be labeled as a lemon law buyback, and it needs to have a disclosure statement on the vehicle by the manufacturer, which is approved through the DMV. So it needs to include these specific words, lemon law buyback, and there's also a paragraph that the manufacturer needs to include with the documents associated with the vehicle. This statement or this document has to include the nature of the vehicle's defects, like what problems the car had, could be engine, transmission, anything. It needs to list all the defects and the repairs made by the dealership. This is to notify people of these repairs and the defective nature of the car, so that the consumer knows what they're getting into. So if you do choose to purchase a car, you know that it had a lemon history.
Y luego, ¿qué pasa después? Después de que uno hace todo eso, ¿verdad? Hay proceso de divulgaciones. Acuerdan los términos. Las partes firman un acuerdo. El comprador devuelve el vehículo. El concesionario y el fabricante envían el cheque y pagan el préstamo. Los honorarios del abogado son independientes de la recuperación del cliente, y luego paz, el cliente feliz. Ley de notificación al consumidor automotriz es un código civil que es sección 1793.23, 1793.24. Anotación y declaración de divulgación de la recompra de la ley de limón en el vehículo por parte del fabricante atrás del Departamento de Motor Vehicles. Es el Departamento de motores vehículos. Incluye la naturaleza de los defectos y reparaciones realizadas.
There. Well, thank you again, Yeva Haroutunian and Roberta Ponce. This was great. Like I said, I learned so much, and yeah, great presentation. That's okay. We know that's Roberta's puppy, Oso Motley. Thank you. Thank you. So I'll go ahead and I'll turn off our live streaming, but then I'll hang out to talk to you both. So thank you, everyone out there in Facebook land. Oops. Stop live stream. Okay.